There we go. Good afternoon, everyone. We hope you enjoyed the beautiful buffet lunch they had for us this afternoon. I know I enjoyed my steak sandwich. Um, my name is Bill Creasha. I'd like to welcome you and thank you for joining us for managing field access and regulatory agency inspections with the infamous Erica Rosasco. Throughout the presentation, please type your questions into the Q&A feature found on the right side of your screen, the upper right-hand side. We'll try and save the last 10 minutes for your questions. We always invite you to use the chat to engage with each other during the presentation, but please keep questions for the presenters in the Q&A, which I will be monitoring throughout the presentation. Thank you to all the Ag Labor Forum sponsors for their support. And our presenter, Erica Rosasco, is a partner at McKague Rosasco in Roseville, California, a wonderful place. She is from a cattle family, hasn't provided any beef to me at all, and grew up in the Central Valley. Ms. Rosasco represents agricultural employers in all aspects of employment and civil litigation. And with that startling moderator script, Erica, take it away.
All right. Thank you, everybody. We have a heavy agenda to go through today since we've got limited time. So let's get to it on field access training, what to do when folks show up, right? Remember, this is not legal advice to you. If you need legal advice, contact your attorney and share your specific situation with them. And I'm going to begin with our first poll of the day. Are you a supervisor or foreman, owner or officer of the company, HR or office staff, industry person, or other? So go ahead and make your choice and submit it so I'll know who we have today. So it looks like lots and lots of HR and office staff, 65%. Just a few owners out there. And go ahead and submit your response as we go through this so that I'll know who's out there and who we're talking to. I'd like to see a lot of supervisors and foremen in there, but so far I'm not seeing any. We have some industry folks and some others. So welcome, everybody. Let's see, get my PowerPoint rolling along. Polling question number 2. When a government agency sends you a letter asking you to produce documents, you should produce everything they ask for, right? Is that true or false? So let's see where we're starting with today, right? And it looks like most of you have it right on. I've got 75% saying false and about 25%. Oh, now we're up to 50-50. We got a lot of responses. So looks like we've got a little bit of learning to do for some of us. We definitely don't want to produce everything they ask for because they always ask for more than they're entitled to, right? Shocker there. Just like an attorney would do, right? They're going to ask for more than they deserve. So who's going to show up and who's been showing up lately and in this time of COVID, right? So we've been getting lots of different letters in requesting information. And I want to make sure we know by the end of today how to respond to those. You're getting things from the labor commissioner that are targeted to farm labor contractors. I would say be careful there turning over any confidential proprietary information. You don't want that subject to a Public Records Act request. So what we have held back for some of our clients is grower information. They're doing desk audits through various agencies. So they've learned how to use Zoom and telephones and things like that to do their work from behind their desk instead of coming out to see you personally during COVID. OSHA has been making some visits, and they've also been doing a little bit of investigation from afar. So watching and observing, taking photos. The DOL is doing desk audits, and they right now have been focusing in on gas stations. But they did promise me within the last couple of weeks that they were going to be shifting that back over to ag. So DOL, expect to get letters and phone calls from them. And so this is going to be right on point with how you're going to respond to that. We got letters from the Attorney General that nobody knew what to do with, and a lot of people didn't respond to. And then they've sort of figured it out that they really needed to pass that back to the individual agencies to deal with. And you want to make sure when responding to any of those that you're doing everything you can to protect your confidential proprietary information, because when we send something into the government, it's generally available on a Public Records Act request. And people like the CRLA, California Rural Legal Assistance, whose job it is to sue you in life, they're trying to get that information to build their next case against you. So you don't want to do that. The other letters that are coming in are from plaintiff attorneys, and they're asking for employees' wage records and personnel files, and they're probably asking you for a whole bunch more. Remember, none of those are innocent requests, and seek counsel before you turn anything over. Remember to have an arbitration agreement in your arsenal of things to keep a class action away. So next polling question is, have you ever had a visit from DOL, ICE, EDD, Labor Commissioner, OSHA, or more than one of the above? So let's see what you guys have had to deal with in the past, so I'll know what we're working with. Lots of you have had more than one. I'm shocked none of you have said DOL. EDD certainly has come out, and lots of you OSHA. Okay, now we've got some DOL folks in there. I would expect that. And certainly some of my clients have been visited by ICE, but so far none of you have admitted to being visited by ICE. So overwhelmingly, it looks like the majority of you have had more than one of those. And then 37% have had, 40% now OSHA, 12% Labor Commissioner, about 14% EDD, and 9% DOL. So, and then more than one is about, right now, sitting at 27%. So, which is what I would expect in agriculture. We get lots of visits, which is why it's so important that we fully understand what to do when somebody shows up. And everybody in the company knows what to do when somebody shows up, because it's not always going to be you that's there to receive them. So backing up to what happened a few years ago that threw everybody into a big tizzy, the sanctuary state law. So part of that got shelved through a court injunction, stopping it from taking place. And that was up here in Sacramento. That is still in place, and I don't expect it to change. Part of it is still in place. And so now employers can voluntarily consent to ICE coming and accessing your workplace. So we're back to basically where we were before, where we cooperate when we can and as best we can, and we try and keep things on a friendly basis. The other thing that's still in place that changed, that's particularly important to know, is if you get an I-9 audit, and that's really what this is, a notice of worksite inspection. It's an I-9 audit. It's all it is. That's the most common thing that's going to happen with anything involving ICE. And so when you get that in, you've got to give notice to your employees that are affected within 72 hours. So if it's for Packing House A, I'm going to give just Packing House A the notice that you've received this I-9 audit, so that they know and understand that has to go out within 72 hours and be posted, and take a picture of it posted so we can show we've complied. You need the name of the agency conducting the investigation, the date we got it, and the nature of the investigation if known. It's going to be, generally speaking, just an I-9 audit. If there's a union involved, you give it to them too. And then any employee who's affected, so if that was Packing House A and somebody from there asked for a copy of the notice, we can give it to them. If somebody from Packing House B says, hey, I heard about this, I want a copy, that's a no. Make sure you're not waiving your 72 hours to produce any documents. And here's the most critical part, and this is the part that drives me crazy when we get involved later on in cases. If you guys don't call us right away and you produce a bunch of stuff to those agencies, they'll never give us back what you produced. And so it's super important that you keep an exact replica of what you're turning over. And ideally, I get it bait stamped. So if we're doing it, I label document 1, 2, 3, 4, 5 with our name on it, so nothing gets lost. And agencies lose what we turn over. So we need proof we sent this over with the initial document production, so that we can get rid of a citation if necessary. And this is with any production you're doing. You want to make sure you have an exact copy. Every time we're left to go back and request those documents from them, they're like, we'll get to you when we get to you, maybe. And we never get all of it. So leave us in a good position. Get your attorneys involved very early on, and we can walk you through the process. I've had clients call me when they're on the phone with an agency, and I'm there to help walk them through, even during COVID. I've listed for you in the materials the notices that you need to use. So if you get an I-9 audit in, that you can go right to that notice in English and Spanish. You've got it ready to go for you. I believe all these are going to be made available to you, and I'm certainly happy to share my materials with you. Once that I-9 audit is finished, you're going to get a notice of results back, hopefully, right? Or maybe hopefully not. But if you get a notice back of the results, right, then you're going to have 72 hours to provide that notice to, again, only the affected employees. And that's usually a notice of suspect documents. And so we're going to have to tell them what they need to fix, when they can meet with us, when they have to correct the deficiencies, which is usually days. It's not going to be the months that we were talking about with Social Security mismatch stuff that we were dealing with before. So this is days. And that they have the right to representation. So, and that's once the I-9 results come back in. So we have to act very quickly and be ready to pull that trigger. By the way, I should mention I-9 audits, they really come in the mail or by certified mail on a Friday. They'll hand it off to the receptionist, the person at the front desk. So that's who needs to know that these are coming, and they'll be due Monday. They have this wonderful habit of giving it to you on a Friday and expecting a response on Monday. And it's to screw with your weekend and to give you as little time as possible, right? So be prepared. You definitely don't want to fix your I-9 situation by re-verifying employees. You can't do that unless you are provided under law. So if you're thinking about re-verifying employees, talk to your counsel, make sure that you legally can do that. Otherwise, you're looking at getting fines. Fines for doing that are between $2,000 and $5,000 just for the first offense, and $5,000 to $10,000 for the second. The labor commissioner is the one charged with enforcement of that. So if you're confronted with an inspection on your I-9s, call your attorney. You got to notify your workers with 72 hours. Once that comes back, you've got 72 hours to let them know what happened, and don't produce anything that's not specifically requested. This is just a little blur of what this looks like when it comes in the mail. It's a couple pages long, and in there is going to be a very specific request of what's requested. And you might be a little surprised, and it may look different than the ones you've gotten in years past. For example, it may just ask you for current employees. Well, the last thing you want to do is go and turn over former employees, right? Because once you turn it over, they can cite you for it. So if you've got errors in those former employees' documents that you can't fix now, right, you're going to turn those over, and now you're all of a sudden your fine's going to go way up. So don't do that. Listen very carefully to what is being asked of you and produce nothing more. A lot of times they're asking for your payroll list and employees, and it's for that day. So you got to take a really fine look and quickly go through your current employee binder and take out anybody who's not current if they're only asking for current employees, right? Because it's for that day. Typical stuff that you're going to see in the request are going to be payroll records, right? Your business licenses, your EIN, your articles of incorporation, your quarterly taxes, any mismatch letters, which almost none of you would have one anymore. The one that went out like last year or so, that didn't have to be retained, so you wouldn't have that. So unlikely to have that. The investigation process is supposed to take a few weeks to a few months. I can tell you I have one that's been sitting out there for a year and a half. Statute of limitations is 5 years, so we still have plenty of time to go. But now I'm sliding into another administration, right? That's going to be a lot more sympathetic to me. So hopefully that one goes off into the ether and we don't get fined. We know that there were going to be errors in it, so that we were likely to get fined. This is just a little blurb to give you an idea of what the process sort of looks like. We've talked about the notice of inspection coming in, them looking at them. They decide, do you have violations? Do you not? Are they technical? Are they substantive? If they're big substantive violations, then they're either going to decide, do we give you a warning, which occasionally happens, right? Or more likely the intent to fine. If they're going to fine you, you can either settle with them or you can go to a hearing. And by the time you get there, you definitely want to be having the assistance of counsel with you to help you through that process. So what do you do when ICE shows up? And this is the most uncomfortable part that I'm going to ask you to do, but you got to get comfortable with this and you got to put somebody in charge of this who has the comfort and ability to do this. Confirm their identity. You've got to confirm their identity. Ask for their business card. Call their agency and confirm that they are who they say they are. You think I'm kidding, but we have people who show up who are pretending to be a government official that are not. Or they're showing up with folks from the government and they have no right to be there. So certainly we would allow government folks on, but we're not going to allow other people on. So confirm their identity. Limit their access, right, to only the areas that you determine they're supposed to have access to, and keep it safe and tight, right? We wouldn't allow them to run around machinery. So anything you wouldn't allow visitors to come and do, we don't want to allow them to do. We have the right to demand a warrant, something that comes from the courts, right? But we may not want to do that. We can demand a subpoena if we want to, but instead we usually choose voluntary cooperation by saying, okay, guys, stop. What are you looking for? Can we narrow the scope? Can we negotiate what you're looking for? You know what, if this is what you're looking for, then you don't need this stuff. Can we agree to produce this over here? And we narrow that scope down. And this is the part, if you're not comfortable doing this, this is something your counsel could do for you as well. If you are going to demand a subpoena or a warrant, just note they're going to come back pretty pissed off and they might expand that scope. So you've got to weigh the benefits there of, you know, what can we negotiate to smooth this over and everybody wins. If it's an actual raid, then they have to have that search warrant or subpoena. You're going to read that document. It's coming from a court. That's going to give you the exact parameters of what they can do, and you don't allow them to go outside of it, right? So if it allows them access to one employee's personnel file, you don't allow them access to everything. You go and you get that one personnel file and you don't grant them access to anything else. So keep them within the four corners of what that allows. When ICE shows up, you want to be cooperative and polite and courteous, right? You want to accompany those officers everywhere they go. You got to take notes for me of everything that happens, because you're not going to remember well 2-3 years from now when this rolls around to a hearing. Don't panic. Don't hide employees. Don't help them run. Don't advise them to run. Those are criminal things. I always take, and say, those are the handcuff things. Don't do those, right? You got to know nobody's required to answer questions from ICE. And so training your employees on this field access is going to give them a level of comfort to know what to do when somebody shows up and what their rights are. And that's so important for them just as much as it is for us, because of all the folks that are likely to show up at your doorstep, it's not likely going to be ICE just by sheer odds, right? And they need to know that. They need to know other agencies are going to come out and see them all the time for lots of reasons, and to not panic, because you could be drawing attention to yourself that you don't need to. And if you run, they're going to give you chase. So don't do that, because they might not be looking for you, right? So consult with an attorney before you grant access, so that you're not giving away anything you don't need to. And this is just a quick summary for the last 3 years to kind of show you where things have been. It's really been the last two that have been so active on worksite investigations and audits, but you look down at the bottom of criminal arrests and it's pretty minimal. I know the Trump administration took a lot of heat that there weren't enough criminal action, and so we saw a little bit more from that alone. So what do you do then, putting aside ICE, when all these other agencies show up, right? It's not really going to be that different. It's just the level of, heart thumping and nervousness is hopefully going to be a lot different, right? So who can show up? Department of Labor and Agriculture, that's a huge one that's likely to show up on our doorstep. EDD, they're looking for 1099s and to make sure you paid your payroll taxes, right? State Labor Commissioner, they come in and they do all kinds of investigations. Police, not likely, right? OSHA, that's another really, really big one. They come in anytime they've gotten notice of something that they need to investigate. Maybe an employee complained or you called something in, and a union could show up. So going to our next poll. Sorry. Number 4. Okay, you got it up. When someone shows up claiming to be an official with the government, you should call the agency to verify their identity, A. B, ask them to wait for a designated company official. C, look at their identification and take a picture. D, A, B, and C. Or E, none of the above. You don't want to make them mad. What do you guys think? Go ahead and submit my answer so I can see your. Oh, you guys are way, way smart. So 86% of you right now have answered D, A, B, and C, and you are on it. You're 100% right and ready for this inspection. So, what do you do when a government official shows up? Remember, government people, they're just like us. They have personalities. Sometimes they're having a good day, sometimes they're having a bad day. A lot of them we know and we work with all the time, and they're great people, right? You just have to treat them with dignity and respect. Just treat them the way you would want to be treated in their shoes. And remember that they get treated poorly all day, every day by lots of people. So be the change in that tide and help them have a good day by being polite and courteous. At the same time, remember, they're being polite and courteous to you doesn't mean you're not going to get fined. It's a technique we use to lull you into being comfortable and blabbing your mouth and giving away information you shouldn't. So be cautious, right? Be careful with what you say. They're not, I always tell people, they're not your friend. They're not there to not issue a citation, right? They're looking for things. So be courteous, be polite, but also zip it when you don't need to speak. Unless you are being asked a specific question, zip it. Don't panic. Have a plan for who's in charge of your field access within your organization. So in each area you work in, you want somebody who's reasonably close to that area that can come in and take control of the situation. So if you've got operations all over the state, you're going to need multiple people who can do that, who've taken a course like this and training and are familiar with field access. Don't volunteer anything, but you should ask lots of questions. Be inquisitive. Why are you here? What led you here today? Did someone complain? Did a competitor complain? Ask, 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 and eventually you're going to get the answer to that. And a lot of times it's just a random show up, right? Or sometimes they'll say, well, somebody called and complained that they weren't getting their transportation pay out of here, and they're an H-2A worker, right? And you go, oh, okay. Well, let's zone in on that, and let me show you that, right? And avoid all this other stuff over here, and let's make it a nice narrow investigation and get to the bottom of it quickly so they can be on their way. Ask for copies of their credentials, call that agency, right? Ask while they're here, get their full name. Don't be afraid, take a picture now if you have your phone, right? And you want to take them to a private area, but you don't want to take them to where other employees are located or going to make people nervous, right? Or where you have private stuff sitting out. You can call their supervisor and verify their identity. I understand it's uncomfortable, but you want to make sure that they are who they say they are. You can try and delay that investigation if it's not a good time. Let's say you're doing payroll. Payroll for farm labor contractors is extremely important because I got to get it out that day, right? I don't have any leeway. So you might say, look, I'm running payroll right now. Can we do this tomorrow? And I'm not putting them off long. I'm explaining why I need more time and when I'm available to do that, right? Or my attorney's not here right now, but if you want to do these interviews, she can be here in an hour and a half. Okay, we'll do them then, right? So offer up when you can make yourself available for that. And then just keep them on course of what they're specifically looking for. And a lot of times they're controlled by their own laws. So, MISPA only entitles them to certain things, and they often ask outside of that. I'll give you an example. They're always going to ask you for your tax returns. You want to know how many times I've turned over tax returns to the Department of Labor? 0. Because they're not entitled to them, and we can simply provide them with the information they're looking for rather than turning over those very private and confidential documents. As the employer, you have rights too, right? You can refuse to allow the investigator on site without a search warrant if for some reason everything got thrown upside down and was awful and they weren't being cooperative or it got very hostile. You can request 72 hours to produce any documents. I often see employers get nervous and they're like, oh my gosh, what do I do? I got to turn this over right now. And they turn over all this stuff and it's wrong. It was like, that was last year's IIPP. This is a blank form you just turned over. If you had stopped and taken the 72 hours, we could have carefully gone through that and said, this looks outdated. Is this the right form? Hey, you gave us this blank form. Don't you have one filled out, right? So we go through and we make sure that what we're turning over is accurate and correct and within the scope of specifically what they're looking for. So take your 72 hours to turn that over. When you can step back, take a deep breath and gather up what you need to gather. You can get counsel to help you with the process. You can request interviews take place at reasonable places and times, right? Obviously, we're not going to do it during meal periods or rest periods. If it's a supervisor or the company owner, right, we're going to have an attorney present. If it's a regular employee, you don't have a right to listen in on that or be part of that, and that's okay. You can participate in an opening conference with them. You can escort them around the property. They're not allowed to be there without you. You can participate in any management interviews because they are agents of the company. What they say is going to bind us. We have a right to protect our confidential information, and we will often label it as such to make sure it's not turned over on a Public Records Act request, and we can participate in that closing conference. Maybe there's a misunderstanding. Maybe we can try and change someone's mind. Maybe there's something we forgot to produce. And we have the right ultimately to contest those violations. Watch your appellate deadline. It comes up super fast, and there's a lot of negotiation that can go on between the time they say they want to fine us and when they actually do to try and narrow that down to something more reasonable. The agency has the right to decline to provide advance notice. They can show up when they want to. They can investigate you with or without probable cause. They have the right to do that. They have the right to inspect payroll records. They can conduct surveillance. They can take photographs. They can collect evidence. They can do employee interviews, and they can issue subpoenas for records and interviews if they want to. You can try and delay this. You can ask them to wait for the appropriate time. You can negotiate a more convenient time or more time. You can tell them if it's going to disrupt your business operations. You want to make sure what you're turning over is accurate and correct because it's evidence that will be used against you later on. And you can ask them to wait a reasonable amount of time, which is about an hour. But if it's going to be a little longer than that, maybe you talk to them about it, right? Never hurts to ask. The worst they can say is no. So when they arrive, you must generally, they have to give you that 72 hours to respond to that demand. And a lot of times, especially if it's Department of Labor, they'll give you a little bit more if you need it. You can decide whether you want to force a subpoena, right, or warrant. But usually it's best to negotiate that so that you can, minimize the amount you've got to produce, right? So don't request an administrative warrant or subpoena unless it's absolutely necessary because you don't want to turn things contentious that may not need to be, right? You may not end up with any fine. You may not have done anything wrong. You may have nothing to hide. You don't want to act like you do. So don't use that unless absolutely necessary. So how do you decide how you're going to proceed? Consider that you don't want to signal, right? You're hiding anything. You don't want to lose control over the scope of that investigation. There's a benefit in being polite and courteous. There's a benefit in being able to negotiate your scope. And then, of course, you can always ask for reasonable times, right? Because they can't interfere with your business operations. So moving to polling question number 5, which I've got all wonky. The employees have the right to refuse to be interviewed by a government agency. Is that true or false? What do you guys think? Can an employee refuse to be interviewed by a government agency? Oh, I see you guys are on top of this. So about 85% of you, 87, right at the very end, said yes, they can. But do they know that, right? An employee can refuse to be interviewed by any government agency. They don't have to talk. They have the right to remain silent. And they may refuse to speak because they're just not comfortable speaking with a government agent. You ask most of them if they know they have the right to refuse, they will, because they're just not comfortable. And I totally get it. You would too, right? Unfortunately, as employers, we've got to speak, but the employees have the right not to. So you might want to, if an employee is going to be interviewed, you might want to try and figure out a way of putting that off so you can give advance notice to employees. Hey guys, look, it's Department of Labor who's showing up. They're going to be asking you some questions. It's okay to participate. We won't retaliate against you if you do or don't. And you have the right to not participate if you're not comfortable doing it. But really, we want to make them comfortable so that they don't think Department of Labor showing up is ICE, or they don't think it's something against them in particular. We don't want them drawing their own conclusions. So if we can forewarn them, of course, be careful with what you say. You can't tell them what they have to say. You can't threaten them. You can't retaliate against them or discriminate against them. You just want to give them a sense of ownership and being comfortable being spoken to. So management can only be present for supervisors, but not regular employees. And you don't want to retaliate against anybody who's spoken with or cooperated in that investigation, right? They become a protected person. And you can assign a contact person to coordinate those interviews, and then making sure you're keeping good records of everything that's done, who they spoke to, maybe how long, whatever it is. Did they have an interpreter? Did they not? I'll tell you, we've seen multiple instances where citations have been issued based solely on the statements of one employee. We talked to that one employee, they only speak Spanish, and the agency admits they didn't have an interpreter. And what the employees has to say is like literally opposite of what was written down in their report. And so that becomes hugely important. Employee interviews are voluntary. They can refuse. Employees shouldn't be intimidated because they look official or have, a uniform or a badge. You do want them to know they're expected to be truthful. I always tell people rule number one in all of this is to tell the truth. If you tell the truth, you're never going to be caught in a lie. And that's all we ever ask of people. And that sort of gives them a sense of calm of, okay, if all I'm expected to do is tell the truth, I can do that, right? They know they can do that, and they're not worried about what they're going to say. I just want them to be comfortable, know to tell the truth, and they'll be a lot more at ease. The employee should listen carefully to the question asked of them, answer only what's asked of them, right? If I ask you, what did you have, or did you have breakfast this morning? That's a yes or a no. If I asked you what you had, now you can tell me, right? But you got to wait for the follow-up question. Don't volunteer things. Employees should never guess or speculate at what they're being asked. If they don't understand, they need to say, I don't understand. If they don't understand their interpreter, they need to say, I don't understand their interpreter. They have a right to talk to facilities and management about their interviews. They can request someone to help them. And you need to make investigators rephrase confusing questions. And if you overhear an interpreter that doesn't know what they're doing or isn't translating correctly, you want to make sure and step up and say something. You want to talk to so-and-so, they only speak Spanish. Do you have an interpreter? And force the issue. Or you let them talk to them and not get the right information, just lay back, later on and say, you just spoke to somebody who only speaks Spanish and you didn't have an interpreter. You're not going to be able to use that against me. So employees should know they don't have to sign anything. They don't have to consent to be recorded. They can take a break or end that interview at any time. They can ask questions of management, and don't sign anything you haven't read and fully agree with and fully understand, or make changes. I've seen situations where they're writing all this stuff out. It's chicken scratch, right? And they're like, sign this. And everybody's like, okay. And they sign it, right? And they have no idea what they just agreed to. And it's not what they had just said. So going to polling question number 6. So supervisors should sign declarations drafted for them by an agency during an interview. True or false? What do you guys think? Should a supervisor sign a declaration drafted for them during an interview by a government agent? Do we want them doing that? So you guys are like right on top of this one, 100% saying false. No way, don't do it, right? So government agents, they will like furiously scratch their notes through. And, you know, as employers, we are just as nervous as our employees because we're the ones that are going to get fined, right? Don't be lulled into just signing it. Don't get convinced into signing it. Don't sign anything you haven't read and don't fully agree with. And you can just choose not to. You're like, yeah, you know what? I'm not signing anything until my lawyer looks at it. There's nothing wrong with that. And I've never once had them come back and say, here's a statement. Will your clients sign it? They know it's not going to get signed, or we're going to make significant changes to it first. Because a lot of what they're writing down is not accurate, and they're writing it how they want to perceive and hear it, not how we're saying it. So there's a bias there, right? We got to recognize it. So never agree to a violation until you've fully considered it and talked to your counsel. If you go to put an investigator off, don't make them feel stonewalled, right? You can designate your attorney as your spokesperson. You can get copies of any search warrant or subpoena that they have. Those cannot be secret documents. You have a right to see them. Don't necessarily accept the first offer made by the inspector. You can negotiate that. And please watch your timeline for appeal. Those come up faster than you can imagine. So polling question 7, supervisors, oops, sorry. I launched the wrong one. Yeah, I must have messed this one up. Signed documents. Yeah, I think I messed that one up. Sorry, guys. We were furiously trying to put these polling questions in, and I definitely messed that one up. Okay, so the focus of the investigations right now are one, COVID-19 is the number one focus. Second to that is payroll records. Are they correct? Do you have all the correct information in there? Are you compliant with Labor Code 226? Have you calculated overtime correctly? Have you calculated rest and recovery correctly? Transportation, they're still looking to see if you've got vans or SUVs of workers and you're not licensed for it. Tools, are you providing your employees with all the tools they need to do their job? Wage disclosure forms, as farm labor contractors, you've got a lot of disclosure forms that are required. Posters, heat stress during summer. Unlicensed farm labor contractors, they're looking for you. They're looking for 1099 folks, you know, when we're switching employees to 1099s and back to avoid overtime. Can't do that. I-9s are going to be less important in the coming years, at least for the next 4 years. Unlawful wage deductions doesn't mean you won't get any. It's just not going to happen nearly as often. Unlawful wage deductions are you charging employees for things? Are employees buying stuff from your supervisors? And of course, whenever there's an accident, even if you don't call OSHA, the first responders do. So you need to be prepared for them to show up. So knock, knock, it's the CRLA. We're official and we're here to conduct an audit. What do you guys think? Are we going to allow them on? No way. These guys are not with the government, or maybe they are with the government, but they're not government actors. They don't have the right to be there, and you can call the sheriff and have them escorted out if they won't leave on their own. So they're pushy, they're brash, and they have official looking badges, so be on the lookout for that. The ALRB also has an education initiative where they're trying to come out and talk to your workers about how to file claims with them. They generally, and they can't come out and educate your workers. If you get an invitation for them to come and see your workforce so they can see how amazing you guys are, I would say no to that. So last polling question of the day. If I showed up at your field today and started chatting with your farm workers, would they know what to do? Yes, no, I don't know. So let's see how confident you guys are all feeling, knowing what we've just gone through today. How confident are you if I showed up and I just started chatting with your workers? what would they do? We've tested this theory out, and I'll tell you, the results are not good. So what do you guys think? How confident are you? So it looks like, see a couple more seconds. Yeah. So you guys are pretty confident. 60% of you think they'd know what to do. About 11% are completely honest and saying no. And another 30% don't know. So I would say if you don't know or it's a no, that is your cue that you guys need to do some field access training and go through all the stuff that we went through here today with your employees and get them up to speed. So when somebody shows up, they know what to do, they know how to respond, and they know what their rights are, right? And that somebody can't just wander onto the property and start talking to folks. And I don't know if Lupe's on right now, but it's something he's done. And he's never been stopped by somebody. He just blends, Lupe is, right? He can chat with anybody. So let me, with that, go to your questions that you have.
Yes, we have questions in the poll. Did you want to pull them up or you want me to read them to you?
I can pull them up. So can they also refuse to answer OSHA questions like heat illness? Or are we talking federal agencies? They can refuse to answer questions from anyone. So they do not need to answer anyone's questions if they're not comfortable doing so. Obviously, if they're comfortable and they're okay with it, they absolutely can. They can ask, well, what do you want me to ask me about? They're entitled to inquire so that they feel comfortable answering questions. Would a crew lead count as a supervisor, allowing us to listen in? I would say that is questionable. The government agencies are always trying to tag anybody with any amount of authority as an agent of the employer. So I would say yes. If a crew lead wanted to be interviewed, I would demand to be part of that interview process and to prepare them ahead of time, right? So with the supervisor interviews, we schedule those. Even if it's just hours later or a day later, and it gives us just that little bit of time to prep them about what to expect and what their rights are. So next question, I'm correct in assuming that all agencies except DOL have to check in at the office. DOL can go straight to the field. No, they can all go straight to the field. They just don't. The only ones that go straight to the field typically are going to be OSHA and DOL. Everybody else is really sniffing around the office, or it's going to be something you get in the mail or a phone call. So, and like one of my clients on the DOL investigation during COVID just got a phone call in, and he literally was like, hang on a second, calls me on his second line. He's like, I got the DOL on the other line. I'm like, conference me in. And of course, we quickly stopped that and said, yeah, well, if you want to interview my client, we're going to arrange for that, but it's not going to be on the spot. So, can we call and verify their identity before they start, or can they start investigating while we're verifying? No, I would hold them for the few minutes it's going to take you to call and verify. So great question. For a written field access protocol, what would be the key components? Are there samples available? I can't remember if I have one or not, but you definitely want to have who's your point person, right? Confirming their identity, reviewing all the documents they have, asking them the scope of the investigation, narrowing the scope of the investigation, negotiating time, trying to figure out who they want to interview and scheduling those, buying yourself additional time. So those are the things I would do. Can employers or their reps require government inspectors to follow protocols on COVID? Great question, Lupe. Show a negative COVID test, wear face coverings, maintain social distancing, have temperature checks. Yes, to all of those. And actually what we have done is for all my clients who somebody's tried to go out personally, we've said no. And we were successful with that with the ALRB. And with Department of Labor, we've said, nope, sorry guys. And a lot of like outside of ALRB, they don't physically want to come out by and large. So, and the ALRB was the one that wanted on, and we said no. And we had to show our COVID preparedness plan that doesn't allow visitors on. And it's not just for them, right? It's everybody. We're limiting contact. So yeah, you can set out the parameters, and you want to treat them the same as you would treat any visitor, and show what your policies and practices are. And it's best if you have that as part of your COVID preparedness plan that I know is going to be talked about during the course of this conference. So make sure you have that in place. And then if there's no real need for them to be there, if it can be accomplished another way, I would suggest you don't have them there. It's just they can do it over the phone, right? Most of the time, or Zoom, or whatever it is. So do you suggest to go to a hearing or settle? So we always try and settle first. Going to a hearing is really scary stuff for a farm labor contractor because they'll threaten to pull your license. Now, if you think you can win, or if the investigator is not being fair with you, not negotiating with you, then sometimes you get backed into a corner and having to go to a hearing. But you want to look at the situation and say, what are my chances of prevailing at the hearing? Am I better off going to a hearing? What am I going to spend to get there? And they know that, right? And sometimes they know if it's a weak case, they'll just give you a small fine, knowing it's going to cost you twice as much to hire a lawyer to defend yourself. So it really depends. It's something you want to work through with your counsel. Most attorneys have a free consultation. If you're not sure what you want to do, just call them and say, hey, here's my situation. What would this cost me? And we give you a quote for free so that you'll have an idea of what it will cost you to go to a hearing versus settling, or just to get involved to get you a settlement. One thing I will say is please, 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 and sorry if they're attending this, but if you get a fine from Department of Labor, those are negotiable. Please, please, please get somebody to help you negotiate that down. They're really good to work with and really fair, and they will bring those fines down. OSHA, we have to press a little harder. We almost always have to appeal those before we get any give on getting those reduced or eliminated. So each one's a little different. Labor commissioners almost never willing to negotiate with you, so that kind of forces you to go into a hearing. So it really depends on what agency you're having to deal with as to whether you should go to a hearing or you should settle. All right.
Okay, I have a question, Erica.
Yeah.
Should you post your fields, your property?
Yeah. Oh, great question, Bill. Yes, you definitely want to post your field as being private property, that you don't allow visitors in, you don't allow people to wander in. I will tell you, like, we know Department of Labor has gotten pretty aggressive in getting into private property areas. And in one case last spring, pre-COVID, they waited outside the gate probably for hours until somebody left the gate and they could sneak in to a remote location. But they were looking for someone in particular coming back to basically do a recheck on somebody. So yeah, it does help to post it as private property, so you can say, look, this is private property. We don't allow visitors on here. We'll talk to you, but we're going to talk out here, right? Because you want to talk away from workers, outside of the earshot and eyesight of workers, because you don't want to make them nervous. And by all means, if you've got an office nearby, invite them, to the office to meet there. They may or may not want to, but if it's posted, at least you can meet outside of that. Any other questions?
I don't see any. I don't know if you can see any others.
I don't. I'm just so thrilled that I was actually timely today. So
Well, Erica, we'd like to thank you so very, very much
you're very
for
welcome.
being here. And we want to let everyone know that the session chat is still available after the session ends. So feel free to keep the conversation going. Again, thanks to all Ag Labor Forum sponsors, including McKague and Rosasco. Again, a beautiful Roseville, California. We'd like to thank you for joining us. There's a ton of other good information, good sessions out there. I think this might be the last one for today,
Yes.
but have a great break. I'll see you all in the bar afterwards,
Yep.
and the virtual bar. And we'll see you folks tomorrow. Thank you very much.
All right. Thanks, Bill.
You're welcome.